Hey, all right, everyone. You all right, Will? You all right, Shannon? Welcome everyone in the live chat. Usual stuff. I'll go through a few bits and pieces, then we'll get going properly. Hope you've all had a reasonable week. Well, I guess if you're here, you probably have had better weeks at some point. So first things first, as always, if you want to ask a question in the live chat, you're very welcome to, but just ask the question as if it's about someone else. And the reason for that is so, firstly, you don't have to spill your own personal data all over the internet. And secondly, it's actually because there's another element to it, which is if you ask the question as if it's about someone else, you tend to find it easier to separate the actual factual bit of information you need rather than it becoming just a kind of a very kind of complicated issue. And the other thing to say is that YouTube seems to have a mind of its own. It's now keeping the live chat on the recordings, so you can also delete your messages. So once you've asked a question and it's been answered, you can then delete it again. On that point, we're aware that last week there was a lot of questions and it got a bit manic. It's quite difficult to kind of track all the questions. So Shannon is going to try and record the questions that have been asked with some sort of timestamp on them. Now, we don't know if it's going to work or not, but we'll give it a go. We obviously know some of the questions because they're coming through the week, but we'll give it a go to kind of keep hold of the thing. We've got any regulars. I think Andrew's there. I've seen Andrew. You're right, Andrew. I've seen Nick. You're right, Nick. Yeah, that's and anyone else who's kind of any regulars, just say hello. Nice to see who's here. Just keeping track of the questions already coming in. There's a couple of positive things I've seen there, which is nice. I'll get into them in a minute. Check out talk about anything else. Okay, so also got a question coming through the week about not getting notifications about this. So if you have subscribed to this channel and you need to basically click on the subscribe button and go down to like all notifications and make sure that's selected. So I think some people are subscribed and they're not getting notifications, and so they don't know what's happening. So yeah, just bear that in mind. And then what else? Okay, yeah, two more things. Sorry, guys, more than normal this week. So first thing, I don't do casework. Shannon doesn't do casework. Will does casework, but has is at full capacity. I've had a few emails and a few Facebook kind of questions come in this week, just asking if I can help out. I can't. I'm a painter and decorator. I've been painting today, been sieving out paint today. Had a very long day. That's what my day job is. This is very much a kind of voluntary thing. We deliver training, but it's kind of on set days and stuff. So we don't do casework at this point in time. That may change at some point, but that's where things are at the moment. So don't be offended if I don't get back to you. I won't if I get an email about that sort of thing. And then finally, on the 7th of March, on the Thursday evening slot, we're doing another free event, a panel discussion event about local democracy and homelessness, because Shannon and I have been doing this for years now in terms of just asking questions at the local council and getting them to improve things. And I just wanted to kind of put this out there today, just for those in the live chat. And I don't know how you're going to get back to me about this, but you might be able to either put a comment in the live chat or in a other YouTube video. But basically, what stops you, first of all, involving, if anything, maybe there's nothing that stops you, but what kind of makes you reluctant to involve politicians in your case when you're actually homeless? And it might be because you simply don't know that they're there. And also, is there anything that stops you voicing your experiences in the local council setting? Because we have found that local councils have a lot to do with, obviously, how homelessness is dealt with. And actually, there's a lot of stuff that can be done. And I just wondered, I'm just going to put those two questions out there, really. As I say, it might be you want to think about it and just kind of put a question or put a comment into one of the YouTube videos and I'll pick it up. But yeah, we're just kind of doing a bit of prep for it. We just want to kind of just hear what other people, what their experiences are with it, really. So anyway, the last thing, I was looking at some cases this week. I never knew this. Local connection under homelessness under Part 7, voluntary work counts as employment. There's a case called Enfield v Fox or something like that, or v Enfield XP Fox, where basically, it's a bit of a long story short. I'm going to do a separate video about this. But if you are genuinely volunteering for a charity, let's say, that counts as employment. You therefore have employment in an area that you would therefore have local connection under Part 7. Don't know how it works within Part 6. I would imagine it's the same, but you'd have to apply the Part 6 definition to it, which is different, which is often things like you need to have done it for 16 hours a week, and it needs to have been for at least a year or whatever, maybe 3 years, I don't know, in London. But just thought that was an interesting, so I came across that. I thought it might help a few people out. Anyway, so questions. as I say, we've got 8 that have come through during the week, which are all pretty substantial. And I'm just going to check through. We're going to start with one from the week, and then we'll get into the live chat. So I hope that's all right, guys. And the first one's quite well, it's an infuriating one because this person's been badly failed by the council. But basically, we've got someone who's in relief duty, fleeing due to domestic abuse. They're not placed in temporary accommodation and have been left at the perpetrator's home. The perpetrator stayed away but keeps coming back and going. Yeah, kind of they've got a key. This individual's placed on band D, on the local council's housing register, and there are 4 children. So the relief duty is ended. Perpetrator is the sole tenant and has rent arrears. What can a person do? No one's helping. Housing officer never available. It's it's Medway Borough Council. So I had a little look at Medway's housing allocation scheme early, just to kind of give me a bit of background on this. But yeah, there's a number of things going on here, and I guess we can kind of approach it. There's different kind of levels of stuff that's going on now. I'm a pedant. To do this sort of stuff, you have to be a bit pedantic, but it's kind of in a good way. So the person's kind of asked this question saying they're fleeing domestic abuse, but they're still at home. Now, technically, that's not right because you haven't fled. I know that seems like a really stupid thing to point out, but the reason I'm saying this is that people don't need to flee to be homeless because of domestic abuse. There just needs to be a risk of domestic abuse. That's essentially how the law works. So you don't need to have actually fled a property to enjoy the assistance that comes from the Housing Act. Basically, we haven't got full details here, but in that situation, if you go to any local authority and you say, I'm at risk of domestic abuse in my home, first of all, they should believe you. That's what the LGO says, and it's what the Code of Guidance says. That may mean you don't have any evidence from the police or, Marek or whatever, to back it up. And they should immediately offer you suitable temporary accommodation under Part 7 of the Housing Act. They can also tell you about refuges. They can also support you into a refuge, but they can't just do that because refuges could be anywhere and they're not particularly nice places, not all the time anyway. And so the council should be doing that they should be making that offer immediately. You can turn it down. You can say, well, do you know what? That sounds terrible. I would rather stay here and continue to be abused, and I would get, the relevant kind of banding on the housing register, which I know some people would they kind of balance up the different strains on their family and they kind of elect to do that, which is, they can legally do that. But that's kind of the starting point. So on the face of this question, this person is going to be eligible for compensation from that council. They should have offered suitable temporary accommodation immediately. The relief duty is expired. They should have, should be in contact. They should be making a decision. So that's just the kind of starting point. We'll come to the kind of other bits in a minute. But if it was, if I was supporting that person, then I'd be complaining to the chief exec immediately and all the relevant councillors or MPs or whatever. And first of all, getting temporary accommodation. I'd then worry about the banding. So, this person's going to be owed the main housing duty. So getting the banding up to, I think in Medway it would be A. I think they would get A banding in this circumstance. And that then kind of gives you breathing space to worry about everything else. But that's the kind of first thing. Now, guys, I don't know if you want to kind of tackle the second element of this in terms of the perpetrator being the tenant, the landlord saying that the victim has signed the tenancy. If not, I'll have a go at it. But do you guys want to come in on that at all?
Yeah, I could. Excuse me. So are we saying that they're joint tenants?
No, so they're saying that the perpetrator is the sole tenant.
Oh, I beg your pardon. Okay.
And the perpetrator is in rent arrears, and the landlord's trying to say that the victim is also on the tenancy. I'm assuming there isn't a tenancy agreement signed by the victim to show that, otherwise they wouldn't be saying it. But the landlord, I think, is basically also being difficult. In one sense, I would say that's an academic point because if the council is doing what they should be doing, they don't really need to worry about the landlord. But yeah, I don't know. Anything else you guys picked up on at all?
Sorry if I'm being stubborn. Is the landlord trying it on then? So, I mean, if they're not on the tenancy agreement, then they're not liable for rent.
Yeah, I think the landlord's just trying it on. I think they're just trying to. I think that the perpetrator's left, and the landlord's probably just trying to kind of claw back any money they can by bullying them, basically, certainly on the face of this information. So
think
yeah,
for me, I don't like you said, I don't see the relevance to be honest. In regards to the victim, it's irrelevant, because they're not on the tenancy. Therefore, that should be enough for the council anyway. So if the local authority is getting calls from the landlord saying, they've got rent arrears or what have you, then again, you just say to the council, no, I'm not a tenant. Here's a tenancy agreement where they've signed it and I haven't. The landlord's being difficult. The Section 21 doesn't affect me in any way because I'm experiencing domestic abuse, so I'm already homeless. Um, and that way as well, they're not going to get stuck with potentially being put down in vans because they've got rent arrears, or not being accepted by housing associations because they've got rent arrears. Though I think we've mentioned a million times, you can still challenge those policies, those blanket policies, because they're potentially discriminatory. So yeah, I think you're right. Making a complaint to the chief exec and requesting immediate temporary accommodation, because even though the partner's not staying there, he's coming back, or they're coming back. I think it did say he, um, or repeatedly coming back. So the risk is still there, and it's when you're leaving, you're at most risk, and when things tend to escalate more. So if anything, the risk is heightened. And I'd also potentially be asking the housing officers, look, have you made a safeguarding alert? Have you, made a referral to social services? And again, just to reiterate, we made this point lots, but a referral to social services is not, and should not ever be, a threat to take your kids away. Some housing officers have been known to say things like that. But in this instance, it's about supporting the whole family, which is potentially needed or wanted. And again, I think you can refuse that later down the line and whatnot. But yeah, I'd be escalating it immediately and ignoring Section 21, ignoring the rent arrears, because I just don't, it's not relevant to their situation. It'd be relevant to the perpetrators, but not to theirs.
yeah, and I'd say just the fact that perpetrators coming and going, even if they're not being abusive like directly, if there's been previous abuse and if they've caused alarm and distress, the fact is the perpetrator probably knows that just by showing up is gonna kind of cause the victim to kind of just suffer a lot of stress if nothing else. So yeah, obviously we don't know the kind of detail or kind of the background of it here. But yes, I think, and Shannon said absolutely right. Like in terms of when it comes to writing the complaint, because the complaint, you put the initial complaint in now, just saying, I'm fleeing domestic abuse or I'm affected by domestic abuse and the council's not done anything. But when you get to the stage two, when hopefully when you're in temporary accommodation and you know what's going on, you can start fleshing out that complaint in a lot more detail. So before you do that, you want to make a subject access request. And one of the things you want to look for is, did the housing officer make a safeguarding alert, adult safeguarding alert, a children safeguarding alert? Because if the children have witnessed the domestic abuse, they are technically victims of domestic abuse. That's how the DA Act now works and the definition works. And the housing officers would have received training that if someone is being abused, they should report it. Now, technically, if the person doesn't have care and support needs, or kind of if Section 42 of the care doesn't apply, then the council won't have any duties under that. But they still would have had training to raise the alert, because the point is, as professionals, we're supposed to have a zero tolerance approach to abuse and report things as soon as we're aware of them, with the individual's consent. But that's kind of how it should work. So if there's not that record, if that action hasn't been taken, then that in itself is a failure. But if it has been done, you can then look at what's been reported, because that can then build your case to say, well, the housing officer definitely knows I'm at risk of domestic abuse here. That's why they've done this, and yet nothing's happened. So yeah, I think that's kind of, that would be the first stage. I mean, this would be, in one sense, it takes a year or two to get housed. It takes a year or two to get compensation, but it's something which is definitely worth pursuing once the headspace is there to actually do it. So once they're safely housed, they can start looking into that sort of stuff.
And just on that, Mike, it's 12 months, isn't it, that you can make a complaint. So 12 months after it's happened that you can make a complaint, unless there's like extraordinary circumstances. Because I was just thinking that even temporary accommodation, if the local authority is extra stretched or what have you, your headspace might still not be in the realms to make a complaint and to take it to the LGO. But is it
Yeah,
12 months?
yeah. So it's 12 months, but so the most recent case I was involved in, one of the elements of the case was like from 4 years ago, but the LGO basically interpreted it as saying that it's within 12 months of the person becoming aware of the failure, because they didn't know what the law was. The council had failed them. They were just kind of assuming the council was doing it right, and they weren't. So within 12 months of them finding out about this, they made the complaint, and that was enough. But yeah, as you say, the LGO, I was impressed by how they kind of considered the domestic abuse, and I'd say if you're just not in the headspace for it right now, then I think that would be ample, kind of to say to the LGO down the line. Ideally, I guess it'd be a case of going to local domestic abuse service and seeing if any of them have got enough, kind of courage or whatever to do it for you. My experience is they won't, which is really sad. But it's one sense it's possible to kind of get a good outcome in this situation. So yeah, unless we've missed anything, we'll move on. Hopefully that was useful. So if we go to the chat, so we just got a question from someone who they asked about a friend 6 months ago. The council's now accepted full duty. So this couple, I think it was, they got a solicitor. Looks like the council basically folded at the last minute, which if it was me, I'd complain about that. And I'd say, you knew full well that this couple were in priority needs. You just tried to play the game and kind of put it off. And then when the solicitor actually got involved and the court case was actually going to happen, that's when you folded. And I'd just raise this complaint. I don't know if it'd be upheld or not, but I just make that point to say they knew, they would have known, they would have known that was the case, and they've just kind of played the game a bit. But anyway, the question is, so they're now owed the full housing duty. They're at the high, I assume this is the highest status, so highest banding, so it's gold banding. In most areas that use gold, silver, and bronze, gold is the highest. There's sometimes, I don't know if there's a platinum somewhere, but anyway. So they're able to bid. There's not much one-bedroom stock. Any advice, please? So one thing you can do in this situation is you can ask the council for their average waiting times, because it varies massively, area to area. And if, for example, you've got, say, a need for accessible housing, so you're a wheelchair user or something, then you can specify, what's the average waiting time for people who need accessible accommodation. You can do it through you can either do it directly with the housing officer, and if they're helpful, they'll let you know, because they'll have those stats at their fingertips. Or you can do what's called a freedom of information request, which is where if you just Google your council's name and FOI, you'll get an email just from that, and you can just ask them, what's the average waiting time for a couple without children in gold banding on the housing register, and you'll get an idea. Because if it's 10 years, if it's 10 years, or if it's 10 days or something, that makes a difference to what you're then going to do. So it's obviously only an average. It's not guaranteed that you're going to get a house in that time, but it's an indicator of what it's going to be. And you might also start looking at pots of money that are available, grants, welfare provision grant within the council. Often there'll be lots of local little charities that kind of do stuff. So if you've got local Emmaus, you may well be able to pick up white goods, settees and stuff like that, just to kind of get ready for the move. But that's all you can really do. And also just kind of read the small print of the letters you've been given, because councils do this differently. But if you don't bid on suitable properties, then they'll just put you on auto bid and they'll just stick you somewhere you don't want to be. So you just want to kind of see what the small print says about that. So you want to be bidding on every round, which is, I think, is what this person's doing. But yeah, anything you want to add to that, guys?
Just so I heard the second hand, so don't hold me to it. But where someone was able to contact the housing association via the bidding system and the local authority together, and say that actually they were open to bidding on like a wider local area, which included just more homes. That might not always be possible, but potentially if you are open to living, I don't know, a little bit further outside of where you are currently, that potentially could speed things up if you were willing to sort of expand your area. And obviously circumstances, some people aren't, and it also might not be possible. But it might be worth an ask.
Yeah, cool. Okay, I'm just already perplexed by the chat. It's all good questions, but I'm just making sure I don't miss anything. So someone's just saying they've got main housing duty today. Thanks for all the advice in previous weeks. That's really cool to hear. Good stuff. I hope that, yeah, same situation for you. You're now main housing duty accepted. You now got to wait and kind of work out how long you're actually going to be there. So same advice for what we just said in terms of kind of what you can do to actually get a better idea of how that's all going to work. Let's do one more from the chat, and then we'll go back to the kind of preset ones. Shannon, I don't know how. Sorry to. Yeah, are you keeping up? Yeah, nice one. So someone was living with parents and had suffered from domestic abuse. They were not on the tenancy agreement for their parents' private rent accommodation. Why do they have to provide a tenancy agreement to the council with their name on it? They don't. I don't. On the face of that information, they don't. There's, if you're at risk of domestic abuse, and obviously we're not sure here whether it's from the parents or from a partner or something. But basically, I mean, yeah, I guess the council might want to know if you've got any legal rights to property, but even then, it doesn't necessarily make any difference. If you've got a tenancy or if you own your own home, but you're at risk of domestic abuse, then you're homeless legally, so the council have to kick in at that point. But yeah, I know some councils, like, they'll insist that your parents write a letter saying that you can't stay there anymore and that sort of thing. That's not legally necessary, but if you can get it, you might as well play their game and just get it done, because it's probably not worth dying on that hill if you can help it. But yeah, again, anything from you guys on that one? There is no reason. I mean, you could ask the council housing officer, why do you need this? It doesn't exist. I think you can ask that question and see what they say. Always do it in writing. Don't talk to them on the phone. There's no point. Just email them and just ask them, why do you need to have? It doesn't exist. Why do you need it? And see what they say. But yeah, unless we've got anything on that one, guys, you're good.
Yeah.
Yeah, cool. Okay, so let's go back to the one that's coming through the week. Any advice? We have 7-month-old baby, 3 of us living in one room private accommodation. Other facilities are shared. It's very crowded. Do we have a chance to get a council house? We've only lived here 1 year and 8 months. So I'm not quite sure if that means in the country or that in the area. So it sounds like they're in a HMO, a house of multiple occupation, with a baby. Now, first thing I would do is actually check what the tenancy says, because in a lot of HMOs it will say specifically you can't have kids here. And if it does say that, then it's obviously not reasonable to continue to occupy, and therefore you can make a homeless application there, and then you'd have to wait to be evicted or anything like that. Will, do you know, like, what the kind of, what the law is on this bit?
No, I didn't know. Excuse me, I didn't know if there's any particular law that says you can't be in an HMO in that situation. I think it would just turn on whether the accommodation was suitable for them in the round, as it were. Because if it's 1 bedroom, it may. The odd thing is that obviously if the council put you in there themselves, it would be unsuitable. So you'll because it would be classed as bed and breakfast, presumably, if it's got shared facilities, unless it's got ensuite facilities. But it's tricky, because if there's 3 people and a baby live, it may not even be statutory overcrowding. That's the problem. You agree with that, Shannon?
Yeah, I don't think it is, because I from memory, someone under 12 months
That's right.
doesn't count
The couple
towards
would be.
a room, and so a couple's fine to share a room, and they've only got 1 room, so they wouldn't be overcrowding.
But other facilities are shared, so it may be arguable that it's not suitable because of the sharing. But it's worth having a go. But to answer the question, do we have any chance to get a council house? I'll just say 2 things on that. One is, I suppose everyone's got a chance of getting a council house if you apply, but that doesn't mean that you will. And on those facts, I think you probably wouldn't, in that you're not going to go to the front of the queue. But what you could do, if you're perhaps, I think a lot of people do confuse this, getting a council house and getting housed by the council are not the same thing. So you could still be entitled to get rehoused under Part 7 and put into more decent private accommodation, which may not be the solution everyone wants, which is the security and the more cheap rent, but at least it would get you out of that situation. So I would say apply and see what you get.
It just so happens I published a video 2 days ago about, like, council home private housing, whether you get it through the Part 7 process. So I think I did a fairly good job on that this time. But yeah, cool. Okay. So that's that one, and then we'll do one more from the week. So someone's homeless, they're pregnant, so therefore they're in priority needs. They're housed in another borough in private rented, given a 2-year tenancy. So I guess that means that it was a Part 7 discharge into the private rented sector. So the council owed them a main housing duty, and they've discharged that into a 2-year tenancy. I mean, technically they only have to do a 12-month tenancy in that situation, but the 2-year might be relevant to the kind of protection period. So because when you get a letter, it should say if you become homeless again within 2 years unintentionally, you're still in priority needs regardless of your circumstances. So they've maintained their tenancy for 3 years, so they're now a year past the 2 years. But could they basically, can they join the housing register? It seems that they're at risk of entering the housing crisis cycle in terms of getting no fault eviction, just going round and round. My area says I must live here for 5 years to be put on the housing register. I've only been here 3 years, so I'm stuck. So it's a good question. Basically, at this point in time, you can apply to your housing register, as Will says, anyone can do it. My guess is that you won't actually qualify to get on a housing register at all at the moment, not because of local connection necessarily, but because on the face of it, you are technically suitably housed, so that you don't have any housing need in that situation. So yeah, that unless there's something that there's not in the questionnaire about whatever abuse, harassment, something like that, or unaffordability or something. But if assuming that those don't apply here, then most areas, certainly closer to London, you won't even get a banding at all. You won't even get the lowest banding if you're not homeless. You don't hit any of their criteria, and so you won't even get as far as finding out if you've got local connection under Part 6 or not. But even if you did, so even if you had housing need, then yes, unless you're homeless, you're still going to be subject to the 5-year local connection criteria rather than the homeless local connection criteria. This is something I need to do a video about because it's so confusing. If you're homeless, the local connection criteria is much easier to satisfy. So it'd only be 6 out of the last 12 months. So if you became homeless unintentionally from this private rented accommodation, you can make a homeless application to anywhere you've got. We can make it to anywhere, but you would want to make it to somewhere where you've got local connection, and you would satisfy that residency in that area if you wanted to. But you would need to be served a Section 21 notice, and you need to be unintentionally homeless. Anyone want to add anything to that? So I think it's a question that affects a lot of people. So that's a good question. But if not, we'll
I think you covered everything there.
Yeah, cool. Okay, let's go back into the live chat and have a look. Sorry, Shannon, I'm going to keep going from one to the other. So, unless I've missed one. You're right, mindset reset. I've made stage 2 complaint, also complained to the MP. I've requested a formal review. I only got told that I'm on the transfer list after I made all the complaints. The council asked me if I want to, what I want to do. And out of nowhere, the council asked me if I want to do a suitability review. I'm currently waiting for a stage 2 response by next month. I'm really confused what I should do. Okay, so one thing to understand about complaints is they run parallel to the review process. So let's say you get a non-priority decision, and let's say it's ridiculous. It's so stupid, no sensible person could ever come up with it. The council's disregarded really obvious information. They've treated you badly. You can make a complaint of that, of the way they handled that decision in terms of how they were with you, and you can also ask for a review of the decision that you're not in priority needs. And in one sense, if you want the council to accept that you're in priority need, the complaint in itself won't do that, because what you need to do is you need to run down the review process. It's called Section 202 if you're interested, but you don't need to know that. In a council decision, it will say, if you're not happy with this, here's who you need to write to request a review, and you've got to do it within 21 days of receiving the letter. So you can have these situations where you've got, the council's failed in multiple ways. Some of those failures have been dealt with under the complaints process, and some of them have been dealt with under the review process, and they don't really interact. And I guess that's something to, so it sounds like you've made a complaint about the suitability of the accommodation, and they've said you need to you need to submit a suitability review of the accommodation, because technically, and I don't know if this is true or not, I think what the council say is the complaint process can't make a determination on whether you're in priority need or whether the accommodation is suitable. That has to be through the legal process. The complaint process tends to be about how the council followed the process through. So yeah, again, guys, anything to just to kind of add into that, or kind of, I think I've understood the question right.
Yeah, there's a little bit more about from the same person. I don't know if you saw that further down. In fact, it's the last one saying that the background to this is that the person and four children are in a one-bedroom hotel. Now, I was saying before that didn't sound like overcrowding from the previous one, but this one does sound a bit more like it. Plus, if it's a hotel, it may be unsuitable. I mean, it may not be, but if I'm right in thinking, if it doesn't have, because it used to be bed and breakfast was unsuitable because it had shared facilities. So if they put you in a travel lodge, that was suitable because it didn't have shared facilities. But I've forgotten they changed the law. And I'm just having a mental block on. I think they said if it doesn't have cooking facilities, it's unsuitable. Can anyone remember? Is that how they got
I
hotels?
think they literally said like so a hotel like Travelodge would be, it would come under the 6 week limit.
Yeah,
I think it was, I don't think they went into more as much detail as that. They just said hotels.
there has to
Yeah,
be some way you define a hotel in terms of these things. Otherwise, you just put a sign on the door saying this isn't a hotel. Like they used to do this with bed and breakfast. They'd managed to call it bed and breakfast in the old days when it was good to call it bed and breakfast because you'd have no rights because they'd leave some cornflake, a little packet of cornflakes outside your room in the morning, even though you were a tenant, and they'd say, "Oh no, it's bed and breakfast. You got breakfast here." But I think here, if they're in those conditions, it'd definitely be worth requesting a review because it sounds like this is temporary accommodation pursuant to Section 193. They've accepted full duty and they put them in there.
so
And so yeah,
I think this might be the same person that asked the question in the week, and
all
basically the
right.
question in the week was the council's accepted that I'm in unsuitable accommodation, but I'm still here, and this relates to a case 6 months ago, where that was found to be unlawful. I can't remember the name. It's began with a G or something, but basically, I don't remember. I think it was Lambeth, maybe. I don't know. But basically, the council has said, yeah, fair enough. We accept you're in unsuitable accommodation. However, we haven't got anywhere else for you. So you'll have to
Oh, right.
wait. And
You mean
the
they say
judge
you're
basically,
homeless because you're in unsuitable accommodation?
yeah, well, I think the judge basically, did it go to the Supreme Court or something? Basically, the
Yes.
judgment said, you know, council was that council was nowhere near close enough to showing that it genuinely had no resources to discharge or to ensure that accommodation was suitable. Maybe it's like November time, even as recent
I
as that. I
think it
can't
was
remember now.
called, there was two cases. One was called Imam and Croydon, and the other one was El Kundi, which was a while before. And in both cases, they were saying, sorry, we haven't got anywhere. And they said that's not a good enough excuse. I mean, it may be for the first couple, you can't go running down to High Court the day after you get a Section 193 duty because they haven't given you anywhere. But, I got an order against a local authority yesterday in the administrative court where they'd accepted they were in their accommodation was unsuitable in November, and they just kept saying, sorry, we're looking. Damn, sorry, I knew it was going to happen.
So,
Right.
do you need to answer it? Well, it's fine
I'm
if you
back
do.
now. No, it's
Yeah,
just
cool.
so yeah, and we got an order and the judge said no, this isn't good enough. But what the judge said is you've got to come back very soon and give an explanation of why you're not housing. And believe it or not, having said they couldn't find anywhere for 3 months, the day we got the order, the next day they found somewhere. So I think they've got a cynical policy of saying, well, let's just wait. The people that get the court orders will house them. So yeah, that's so I would say this person should definitely go for it because if they've accepted the accommodations unsuitable and you've been there for a while, it's worth sending a pre-action. Hang on, that would be no, you'd need to we see you don't even need to go for a review of suitability because they've accepted it's unsuitable. So you just go straight for a judicial review, which is much quicker. Does that make
The other,
sense? I'm not spouting jargon.
yeah. So the other thing is, so I'm just trying to. So the LGO did a report on unsuitable temporary accommodation in May last year. Now I'm not going to prove where to find it. I'm pretty sure. So the LGO is completely separate from the courts. It's not. It's a completely different type of organisation. And ordinarily, to get to complain to the LGO, who would recommend compensation and recommend the council sort themselves out, you have to go through the council's complaint process first. However, I think with regards to unsuitable temporary accommodation, they said you can go straight to the LGO. I'm going to see if I can find that, if it does say that, before the end of tonight. I'm just on the LGO website now. I've searched it. The report is called Unsuitable Temporary Accommodation, very imaginative. And as I say, May 23. So I'm going to see if I can dig that out, because I think as well. So if you weren't able to get a solicitor, you could complain directly to the LGO, I think. But don't do it unless I confirm that before the end of this evening. So yeah, but yeah, I think again, if you can't get a solicitor, same things would apply in terms of going to your local politicians and kind of just kind of maybe quoting that law, the Croydon one that Will just said, which I've already forgotten. But basically
Imam.
just saying, this. Say again, Imam.
It's Imam, yeah, IMAM.
Yeah. So just quote it and because there's the other thing is, if you Google it, so if you Google Imam v Croydon, you'll immediately get a number of like explanations of it. I think Garden Court Chambers did one, Giles Peaker certainly did one on Nearly Legal. So you would be able to kind of throw that at the council, because they won't have heard of it, and they can just read through it themselves as a layperson and say, "Oh, truth, this council better actually do something now." But I think Will's absolutely right. Councils probably they'll just they'll often just do whatever they think they can get away with. And so unless you challenge it effectively, you're still going to be there in a year's time. So yeah. As I say, I'm going to keep digging around in that LJ report. If anyone else in the chat wants to help me out and find that bit that it says that, or it doesn't say that as well, that'd be cool. So let's get back to where are we up to? So question there just about protection of property. So if the council gives me temporary accommodation, do they have a duty to provide me storage for my things till they find me a permanent place? So if you Google Homelessness Code of Guidance, chapter 20, chapter 20 is all about protection of property. And there's basically, it sets out the criteria. So the answer is to this question is potentially. It just depends on whether you meet those criteria. And I think the criteria are, you've got property which is at risk of loss or damage, and you cannot, you yourself have not got the resources to look after it yourselves. And someone in temporary accommodation would be owed this duty. And in that situation, the council would have a duty to protect your property. Technically speaking, they should have actually asked you that, because if you go back to section 184 of the Housing Act, which is the entry level one, the best, the most important section, it basically says if you make a homeless application, so you tell the council you might be homeless and you ask them for help, one of the things they need to immediately do is to work out whether they owe any duties under this part of the Housing Act, which include protection of property. I think it's section 214 or something, 212 or something. So they should have asked you. They often won't, obviously. But the thing with protection of property is that they can get quite creative with it. So, and they can do it as a loan. So they can pay for a man in a van, but they'll kind of say, well, now you owe us £100, and you kind of have to pay it off at an affordable rate. So it's not magic, but it's certainly, and again, it depends how difficult the council is with it all. But it's something that they should be doing. Shannon, have you found something useful about the temporary accommodation thing? So I missed that message.
Yeah, so on page 3 of that report, it says where a council decides that temporary accommodation is unsuitable, at first instance or following a review under section 202, we do not expect complainants to use their section 204 right of appeal to court or to judicially review the council. Complainants should therefore be signposted to the council's complaint procedure and then the ombudsman. I think that's quite good, really, because it means that you don't have to go to a judicial review or appeal to court, which are quite intimidating things, and there's a shortage of lawyers, and legal aid is potentially confusing for people who aren't in that sector. And it's good, like, if the ombudsman said it, then it's also a thing that you can say to the council, well, actually, I can go through your complaints process for this, and then I can take this to the ombudsman, which might lead to a change in their decision.
So it's not quite as good as I'd said it was, but it's unusual in the sense, you remember I said about 5 minutes ago, so I was saying things either go down the complaint route or they go down the court process, and they generally don't interact. What the LGO is saying here is that they do interact in this case. So, but you would still need to exhaust the council's complaint process, which is unfortunate because they can take months. So you'd have to, again, if you're going to try and do it, this is time sensitive, obviously. Copy in your local councillors who are relevant. We talked about this a few weeks ago. So your local ward councillors plus whoever deals with housing in the portfolios, and just kind of make the complaint that way. And I'd say that maximizes your chance of getting a kind of a speedy response or a faster response anyway.
Can I
So yeah,
ask just a couple of clarification questions, just so that people can come back? There's mainly this. Somebody's asked a question. Can you explain what section 1892 is? I was wondering, do you mean section 189A? Because section 1892 just says that the Secretary of State can classify different people as being in priority need, but I don't think that is what you mean, unless I'm missing the wrong section. I'm reading the wrong section. Do you see the question?
a lot of section 189 is the complicated bits about the relief duty.
Yeah, and I think 189 is 189A, isn't it? That we talk about a lot. So
yeah,
I
try
question
not
about
to,
that, but I thought I'd just ask them to clarify, because if they say no, I mean, I do mean the Secretary of State may by order specify descriptions of persons, then fair enough.
Well, that's an easier question to answer.
And there's a very quick answer.
Let's see what they say.
That the highest band in Hounslow Council is not band 2, it's band 1. And I just checked that.
Yeah, so often councils quite often have a system where they have like the highest band, which is like for very exceptional cases. Then the next highest band in most, probably more than half of the councils, will be for people who have got main housing duty accepted. But it does vary from place to place. So yeah, I mean there'll be a band 1. It just might be very, very difficult to get into it. So it might be like, I don't know, your house is burnt down, or you kind of got terminally ill or something like that, where there's kind of like that level of kind of rush. So we need to do a proper video about this question about the section 21, because it's very good question, very common one. So someone's received section 21. Do you recommend going to the council, or wait for the court order, or wait for the court order, or wait for the bailiffs? It's stressful. So we would do a proper video about this. The short answer is go to the council now. If it's within 56 days, the council have to basically step in and do some useful stuff, including assessing your situation and providing or taking reasonable steps to try to avert you becoming homeless, words to that effect. So you want to do that. What the council will often then say is, well, you need to wait till the bailiffs come in, which isn't correct. But we've made this point several times now. What the law says and what councils do are two different things. So wait a minute, I think have we just lost signal on YouTube, guys? I don't know what's going on there. I'm assuming we're still running. It's just my computer saying preparing live stream, and I don't know what it's doing now. Anyway, so we'll do a proper question about that, a proper video about that question, just to kind of go into the detail. But yeah, email your council now with, if you can get a photo of the section 21 notice, then do that. And basically just ask them for help with housing, and it should be enough to get them rolling. And hopefully step in and do some useful things. So okay, so I think we're kind of nearly up to date with the live chat. Let's go back to the questions from the week, see how we're doing. So is there a difference between discharged into the private sector during the relief period and during the main duty in terms of how much the tenant will have to pay? So yeah, there is some more to that question, but that in a sense is the question. But basically, this relates to a video I did on Tuesday about whether the council, you're in the relief period, the council can make what's called a final accommodation offer, which will be a 6-month short hold tenancy. Or if they don't do that and you're owed the main housing duty, then they can give you a 12-month tenancy. Now, in terms of affordability, the council should never put you forward for unaffordable accommodation. And essentially, and we need to do a good video about this as well. But essentially, if you're having to top up your rent from your universal credit living out payment, the kind of living expenses payment, like the food and utility bill kind of bit, then you're legally homeless. It's not reasonable to continue to occupy that accommodation. So council shouldn't be putting you into accommodation like that at any stage, whether it's a final accommodation offer under the relief duty or the main housing duty later on. Well, yeah, and they can use their kind of contacts with private landlords at either stage. It's not, that doesn't really make much difference. It seems like a lot of housing officers don't bother with this kind of this relief duty kind of final accommodation offer anyway, because it's just pragmatically it just doesn't work, because people then come back around 6 months later and it starts again. So hopefully that answers that question. We've talked about the mother and child who are in B&B, and the council's acknowledged that it's unsuitable, but the council has nonetheless left them in there. So I think we've covered that as well. Shannon, this is a bit of a nightmare for you to kind of keep up with these question things. So thanks for battling with that. By the way, guys, I put in the LGA report I was talking about. Well, we were talking about back then about the suitability of accommodation. So if you want to just check that out. And Shannon, what paragraph was it that you found, or what page was your bit you found in there about that?
So it was page 3 of the PDF, but on the page, and it was the first paragraph on the right hand side of the page, I believe. Which seems like a weird way to say that, but hopefully you'll find it.
So okay, yeah, cool. Yeah. Yeah, cool. So let me just go back to the live chat then. I think we're still we're doing all right there. Have we missed anything from the live chat, guys? I can't see anything. Although like my screen is kind of keeps flashing on and off, guys. I don't know if you guys have got problems with the live chat at all. Let me know. Yeah, in fact, let me know if you don't have any problems with it, because
I've just seen on the live stream us all go black for I think a second and then come back again. So I don't think it's interrupting, but I think potentially, yeah. But if someone in the live chat, but obviously it's 10 seconds delay.
Yeah.
Oh no, apparently it's perfect.
Yeah, so. Okay, good. Okay, cool. Yeah, I don't know. Yeah, no one's going there. Anyway, so right, next question. This is an interesting one. So someone's got the option to go into supported living. Social worker has said they can offer this. Social worker said they would have their own flat, own front door, own kitchen. Not sure if I should go for this or wait for the council flat. Do you know any pros and cons to this? Also, what would happen? Basically, what would happen if I got to a point where I didn't need supported living anymore? Where would I be placed in the housing list in terms of banding? It says it can only be short term or up to 2 years in some cases. So yeah, this kind of supported living. Often what happens in the homeless application process is the housing officer realizes they're going to owe you the full duty, and they'll try just to see if there's any other options they can explore with you. Now, sometimes that's absolutely fine, because sometimes they'll have a better option, but sometimes they'll present these supported living kind of arrangements as a better option, and often they're not. But supported living in itself is a very vague term. So supported accommodation, which is what I would call a hostel, often run by charity like the YMCA or St Mungo's or whatever, where, again, you're making generalizations. Generally, you can stay there up to 2 years. Generally speaking, even if you've got your own sort of your unit in there, you have to deal with, more antisocial behaviour than normal. There'll often be some very strict rules about having visitors and drinking and stuff like that in your rooms, that sort of thing. But not all of them like that. Some supported living kind of arrangements are great. The fact that social workers involved here says to me that it's something different from that usual YMCA sort of setup. So it might be something actually resembling some sort of support for a start. But that's kind of So, but crucially, what you need to understand about these kind of things is that it can basically take you back down down the banding significantly. So you might end up having to wait a lot longer. And it's much easier in most supported accommodation to become homeless. So there's far less security of tenure. And say, for example, you shout at a staff member and they say, oh, you're dangerous, we're going to evict you for that. Then you're intentionally homeless. So there's a lot of reasons not to. If I was in that situation, the only reason I would take supported accommodation is if it's long term. So there's no time limit on it. The staff aren't going to bother me too much. And it's actually a nice place in an area of town I want to be in. Otherwise, I'd wait for the main housing duty, but that's just me. So, guys, do you want to sort of, put your 2 pence worth in there?
I mean, I'm happy to talk from personal experience, because I was in temporary accommodation, and I was offered assistant living, and that's where I've gone into. There are definitely pros and cons to both. Mine isn't anything like sort of YMCAs or like hostels. It's quite chill. There's no sort of rules. I can have visitors, I can have alcohol. It's a nice block, it's a nice flat, like it's quite independent. But it is that sort of interaction with staff. There's the lack of security. So, you know, I've got, I think, a 1 week rolling tenancy. However, there's swings and roundabouts even to that, because mine's with a housing association and yours could be or it could not be. But then if I was looking to move on, I would potentially be able to say to them, right, I would quite like a place like this, and I'd like a place like this with my needs, or, you know, be more specific in regards to location. So the only advice I could really offer is you don't have to say yes straight away. Ask all of these questions, like every single little question you could ask, get it in writing, because again, that was potentially my mistake when I moved in, is I didn't get everything in writing. And staff change. So 1 minute it's sort of one framework, and the next minute it might be another framework, or they reassess. So just making sure that you get everything in writing, and seeing realistically what you want to do, and what you're up for doing. Yeah, it's a bit of a weird one because I don't necessarily regret my decision, but it comes with swings and roundabouts. Yeah.
Yeah. I think as well, like asking those questions and kind of, you know, exercising your, you know, your intelligence to ask those questions. If you're getting like a bit of like a rude response or a bit of an abrupt response, that's probably not a good sign. So if you're gonna go for that sort of setup, then they should be fully happy with you asking questions and kind of scrutinizing what it's going to look at, and asking for things in writing, and kind of, you know, and you know, if you can kind of get a bit word of mouth, you know, but what's the reputation from people who've lived there before is usually quite a good thing. So yeah, but I think there's that. Yeah, I think one of the questions you want to ask the council is what happens if I'm evicted from it. And if the answer is, well, you know, you go back down to the bottom and now you're intentionally homeless and we don't owe you any duty, then you might just want to consider, you know, how that's going to work for you. Because I've worked in supported accommodation and people could get evicted for very little. Even just giving their own opinion sometimes would be enough to get someone evicted. So it's just kind of worth bearing in mind. The tenancy, you know, often obviously lots of problems that come with tenancies as well. But at least you kind of get left alone probably a bit more than with supported accommodation, supported living. But anyway, hopefully that's helpful. Will, you got anything to add to that?
No, I mean the only thing I'm just waiting on one of my cases to hear what the supported housing team have got to offer somebody at one of the councils. But this is the other end, because supported housing can mean two different things. One is it's a sort of euphemism for hostel, but it's also for sort of what used to be also called sheltered accommodation. So it could be older people who, I mean, it's a little bit offensive if you're just happen to be elderly and they say, "Oh, well, you need sheltered housing." I mean, because you imagine some place with a button you press if you sort of need somebody to bring you medication or something. But it's, I've said to the client, "Well, just hang on and see," because it could be that they'll actually come up with something good. And it could also be that once you're in the sort of category of people that need supported housing in that sense, or that you could be more inclined to be looked at sympathetically for housing register purposes, that you'd be seen as a vulnerable person. I'm sorry, that's a very, very bad use of the term vulnerable, because that means something else. But and the only other thing I'd say is beware of refusing anything anytime, because it depends how formal the offer is that you've got. Because if they say, "We're going to offer you this," and you say, "No, I'm not taking it," they could say, "Well, that's an unreasonable refusal." So be careful. Like you say, get it in writing, and if they won't put it in writing, then you're probably safe to turn it down.
Yeah. Another thing as well, so bit of an odd one, but people who've been in supported accommodation for more than 3 months of their life between the age of 25 and 35 get the one bed LHA rate rather than the shared accommodation rate. So just something that, you know, certainly if you've been in supported accommodation yourself, it might mean you're you know, you're kind of you're opposite. I mean, I heard, I didn't hear much detail. I heard about an organization or like an area which was like looking to adopt this kind of like ready for tenancy kind of course that people in supported accommodation had to go on before they would be considered for social housing, which I think is a terrible idea. Partly because a lot of supported accommodation you know, a lot of the rules and the risk assessments they do is really just about supported accommodation environments, which are very different from a tenancy. So they're not even a very good indicator. But the idea that, you know, if you haven't kind of ticked these boxes on this process or something, you know, you will be barred from having your own tenancy is nonsense. Housing First has shown people with higher support needs do better in their own accommodation. As a generalization, I know there's exceptions to that, but that's kind of pretty strong evidence all over the world from that. Someone did say so someone's been served with a Section 21 after they've been sectioned on 136, the Mental Health Act. So I don't know if that means they were sectioned whilst they were in the mental health kind of institute. But basically, I don't know too much about it. So Section 136, I don't know what that is.
I'm just looking at that.
It's not like, I don't know if that's not the aftercare thing, is it? So the only ones I know are Section 2 and Section 3. And I mean, I guess what I'd probably say is if you've been sectioned at any point in your life, it's highly likely you're going to be in priority need through vulnerability, and it's probably going to be fairly straightforward to prove that. And also, there are going to be a lot of people who are told they're intentionally homeless in that situation, but actually they're not, because it was related to their mental health, kind of, what was going on at the time. So a lot of people who are in that system will be owed the main housing duty, but there will also be additional duties under the Mental Health Act, which I don't understand, never worked in that area. But they can include accommodation. It just depends. So
I'm pretty sure, and Will, I know you're Googling away, so do correct me, but I'm pretty sure 136 is involuntary section, because you can voluntary section, which is where you agree to be sectioned, and then you get sectioned where you don't necessarily agree and the police have the power to do that. But I think as well with the 136 section of the Mental Health Act, I think you do get a bit more in terms of the aftercare and like discharge and the stuff that goes on around afterwards.
Yeah,
So
it's
yeah,
the one
it's
where the
go on,
police.
Will.
It looks like it applies to the police taking you to a place of safety, and I'm just looking at what the rights are at the end of it. But I'd have thought with all of those, if you've been detained under the Mental Health Act, you then have these rights to an aftercare support, don't you?
So
Forgive me.
I think it's if it's section 2 is when you're there for up to 28 days for assessment, and then if you stay
Yeah,
in after 28 days, you get Section 3. And I
yeah.
think the aftercare kicks in at that point with the Section 3. So when
Oh,
you get
okay.
discharged, I'm pretty sure you should have it. So I think in that situation, a housing department would say, "No, it's the mental health services duty to support you right now and house you." I don't quite know if it's both their duties, but I think it's certainly mental health duties. So yeah, as I say, what you want to do there is basically make sure that you're in a lot of kind of mental health wards, there'll be someone who knows something about housing. Hopefully someone who knows a lot about housing. There should be, but there isn't always. But essentially, when you're approaching your discharge date, you just want to make sure that you've been kind of talked through the homeless application process, if they're not going to house you themselves. So
And
yeah.
potentially, obviously we're not aware of the circumstances and you don't have to go into it on the chat, but potentially if police were involved and stuff, the local authority might be less sympathetic and they might be quick to jump on an intentional homelessness gatekeeping tactic or even a decision or whatnot. So it's just worth familiarizing yourself around intentionally homelessness, because there is a bit where, oh, what section is it? Where if you've got like a mental aberration, no,
Oh,
yeah,
what 9.17, what code of guidance we're talking here? So you're not intentionally homeless. Is that what we're
yeah,
talking about?
if yeah, so if act was because, say, I don't know, schizophrenia and you've had an episode or what have you, then that wouldn't count towards an intentional homelessness decision because of that section, but I can't remember which paragraph
No,
letter
it
it
It's
is
is and stuff.
9.17.
Okay,
yeah,
cool. Yeah, that's the only thing I say for
9.17C
you.
to be precise. So
There we
yeah.
go.
yeah, yeah. So I mean, I think, as I say, again, if mental health hospitals were any good, they'd have a housing specialist who would know this stuff. But unfortunately, that's not always the case. So so it might be, it might also, I would imagine that you're probably going to have contact with a mental health lawyer in that process, because I'd imagine you get some support from them. You might just want to talk to them about seeing if there's a housing specialist they're aware of, because you want to get housing specialist advice before you think about your options on discharge. So the questions come back again about section 1892.
Yeah.
So which is what we. So I mean, so that's a Secretary of State. I'm going to Google it myself now. Is that what you're saying?
Yeah,
Will?
see if I'm getting it wrong, because I think that I can't see how section 1892 has any impact on a YMCA referral, unless it.
If it's priority need, it might do. So basically,
Yeah, sure. Yeah.
So so I mean, I'm just trying to find it now. So I was googling it. So, yeah, Secretary of State may, or basically, essentially, the Secretary of State may define what vulnerability means. I think that's what it's basically saying here. So priority need. So YMCA's it's such a bizarre system. Councils have duties to people with higher support needs through priority needs, but hostels will also house. They're supposed to be there for people with higher support needs. They're not supposed to take people without support needs. Now, if councils were doing their job legally and actually housing people who are in priority need, as they should be, and it's not a very high threshold, then YMCA's and that kind of setup wouldn't really need to exist, in one sense, because priority need through vulnerability is really about, is this person at risk of not being able to, kind of escape homelessness if they become homeless because of something, they're affected by. So most people turning up at home to services will probably have a priority need through vulnerability of some kind if you actually, bother to talk to them. So now, whether the question, I think my guess would be, is that a certain council has got a policy which says people who are in priority needs either need to go into the YMCA, or people who are in priority need can't go to the YMCA, is what my guess is. So I would say a good council officer, you make a homes application and you're not in priority needs, they would immediately be looking at supported accommodation options with you, because that might be all your road at the end of the process, and that's a good, that's sensible. That's what they should be doing. And they might also say, if you are in priority needs, we can also offer you a referral to the YMCA, but it's not, that you don't have to take that, and they should explain that, we're going to owe you a main housing duty, so don't worry about it. And so you then only get a very small number of people who actually want to move into that type of environment, in my experience. Most people, and as in like 99% of the people I've ever worked with, would rather have their own place, own front door, that sort of setup, rather than a room. Sometimes I know hostels that are shared rooms. It's just all the other reasons we've already talked about. So that's so I think the answer is, legally I don't think there is a direct relationship between supported accommodation referrals and priority needs, but locally there might be some particular policies which are sort of trying to steer people towards one or other option of it. I mean, a lot of supported accommodation will say, oh, you're too high needs, we can't manage you, and yet they're then found not in priority need by the council. There's all sorts of weird things that happen that shouldn't. But yeah, I don't know. Hopefully that's useful. We're kind of speculating on what that question's about, but I think that might be something like that. Right, so we're overrunning 8:30. We've got 2 more questions from the week, so let's just dive into them. And I don't know the answer to this one, so Will, hopefully you'll help us out, because I don't think me and Shannon kind of have a lot of respect for the relief duty in general. Don't pay much attention to it.
Right.
But so it's number, I think, 7 on our thing. So what is the difference between the relief duty and the main duty in terms of what support the council will provide? So if you're owed the main duty, the council will house you effectively, whereas if you're at the relief duty, they may not do. But in terms of the support available, I don't know if they're talking about the literal support. In the relief duty, the council's got to take reasonable steps to help you find housing, whereas the main housing duty, they've got to house you. So it's a very different kind of beast. But yeah, Will, do you want to talk about it?
Without thinking I'm missing something, the relief duty is just that initial 8 weeks where they have a chance to help you find, as you were saying, a 6-month assured short-hold tenancy. In terms of support, if you're if you're in priority need, then they'd have a duty to provide you with support as temporary accommodation under Section 188. And then the support under the main duty is obviously a duty to secure that suitable accommodation is made available for you. But beyond that, there's no big difference with the support. I mean, it just depends on priority need.
I'm listening.
Sorry,
sorry,
mate.
go on.
Yeah, you say.
Well, I was just going to say, so in the relief period, you've got the personalised housing plan, and that basically vanishes when the relief duty ends. So the personalised housing plan should be this collaboration between you and the housing officer, saying, what kind of accommodation you think you need and what other support you might need. So you might need support from other agencies or something. But when the relief duty ends, and the council don't have to end it after 56 days, they can let it run on, but they probably won't. But basically that sort of vanishes. So if you're not in priority need, when that relief duty ends, there's nothing the council have to do in terms of support at that point. Whereas if you are in priority need and you're owed the main housing duty and there are some other criteria to it, then their support they would offer would continue. So hopefully that kind of makes sense.
Could I just add one more thing about the relief duty, which I've been looking into this week? One of the problems you get there's two problems you get with the relief duty. One is that you can apply to the council, let's say on the 1st of February, and you don't hear anything for ages and ages and ages. And after you make a complaint on, say, the 1st of April, they say, okay, we'll accept relief duty. So you've lost 2 months already, and then they've got another 2 months. So I was talking to somebody today and I was saying, what do you think you could do to speed that up? And as a lawyer I was talking to, they said, well, after you've had a reasonable time, maybe a week or so, you could threaten them with legal action if they haven't accepted a relief duty, because you could say you've got all the criteria are met, you just haven't bothered to do it. But you should, I think, make a complaint if they haven't indicated what duty they owe you within a short time. The other thing, sorry, go on.
I was just going to say, I think that's what was intended. So I think when the code of guidance was written, they were not envisaging councils would take ages to accept the relief duty. They were kind of saying, well, you make the homeless application, there's reasons to believe you might be homeless, and then the council satisfied that you are homeless. It shouldn't take very long at all. So I don't think there's any kind of time limits set in the code of guidance, because I don't think the code of guidance ever thought councils would do this, but they are doing it, obviously.
Yeah. And the other thing, at the other end of the relief duty, the problem you get is you get them saying, we've accepted a relief duty to you and it'll last for 8 weeks. And then the 8 weeks runs out and you never hear from them. And you say, well, hang on, what's you doing now? And nobody's picking up the phone or replying. And so you can be waiting ages to know if you're owed a full duty or not. And you should definitely challenge that as well, because they really should they should let you know straight away after the 8 weeks is up whether they owe you a full duty or not. And if they owe you a full duty, that does mean that you can do things. Well, you're in a stronger position to ask for different accommodation, because they may only put you in very temporary accommodation to start with, or they may not give you any temporary accommodation. So I would just say make sure they do accept a relief duty, and that they then tell you if they've accepted full duty when the 8 weeks runs out.
Do you think people would be successful once the local authorities accepted that duty, but say it's taken 3 weeks, do you think it would be worth sort of complaining and asking the local authority to backdate when the application was made, and not necessarily from day one, but like you say, maybe day 5 or after a week of 5 working business days, and going, actually that's more than enough time for you to have started looking into my case, therefore I'd like those 2 weeks back. Do you think that would have teeth or not really?
Yes, because when you make a complaint, you get that bit where sort of there's 3 parts to it, aren't there? There's sort of tell us what the facts are, and then what is it you'd like us to do, and maybe just 2 bits. And when it's the bit, I mean, you could say, I'd like an explanation for this, and I'd like you to get somebody to answer my emails. But you could say, yes, I would like you to treat my relief duty backdated to the date when you should have accepted it. I don't think, you're not necessarily going to get much more out of it. Nothing will materialize other than possibly the 8 weeks running out more quickly.
Well, I guess as well, like
Oh,
going sort of like thinking big picture as well. Actually, if they were to respond and say, "Do you know what? We're so stretched because housing officers have a caseload of 100. We didn't actually open your email until like the 3 week mark." Then you could almost take that response to, your local housing committee and be like, "Is this good enough?" And sort of almost pressurize them into getting more staff potentially, or whatever that looks like, or just trying to help them in terms of response times. I think it might be worth doing, even if it doesn't necessarily
yeah,
help
I agree.
you specifically. Do you know what I mean?
Yeah, no, I agree. I think that'd be good. The other thing I'd impress on people that need to complain about and put pressure on councils to do is to carry out this housing needs assessment. Because my view is that it's just not being carried out. And because for years and years, councils just did that thing of checking whether you were eligible, homeless, intentional, priority need. Those were the only questions they asked. And they were asking them in a negative way because can we find an excuse to turn you away? And then suddenly in 2017, the government says, no, you've got to take a positive, helpful approach and look at how they became homeless, what their needs are, what the support needs are. But they're not doing, there should be a report on the file called Housing Needs Assessment Report, but I've never seen one. I've been doing this for ages. And then it's supposed to feed into the personal housing plan because the personal housing plan is supposed to be a plan based on your personal circumstances. But all you get with personal housing plans when you see them is just a load of gumph about you would like somewhere to live, and what you need to do is look for somewhere, which, I mean, is worse than, it's not much use. So I think that people should put pressure on councils for good practice. I mean, you should ask for copies of the file and see if this thing exists, and if not, say what's happening. And it may be useful later down the line if they say, we think this place is suitable for you, you've got more evidence to say, well, you've never assessed what my needs are and what would be suitable for me. So how can you say that?
Quite often quite often the assessments I've seen are kind of, they're like these IT printouts of this tick box exercise the officer did, and you have situations where they'll identify the person has a disability and then nothing is done with it. So that was kind of part of a complaint I've run before, where I've said, well, this person had disabilities, and yet there was no actual, no meaningful response to that, and I think that was part of the upheld bit. So it's
and the code of guidance says they should have a meeting to discuss your circumstances with you. I mean, it may not be in person, but they'll definitely need to sort of interview you and discuss that, rather than just say, well, by doing all the stuff we normally do, we've sort of obtained the information by default, which they haven't.
Quite often they'll also say, like, oh, you need to look for private rented, go look in the private rented sector.
Yeah, that's often what the private plan says.
And the housing officer knows full well that that's not, for 99% of the people, they're not going to be able to actually do anything with that. But then it's kind of like, I get really annoyed when housing officers know full well there's nothing in the area for that amount of money they're going to get, and yet they just tell everyone that and get annoyed with them when they haven't found something. It's like, they're not all going to be able to find something. So last question, guys. We're just overrunning as normal now. We need to have a talk about amongst ourselves about if there's a more efficient way of doing this. But anyway, so landlords wanting to sell the flat. 70, got various health issues, heart scans going on, things like that. First floor flat, which don't help. COPD and blackout. Would I be entitled to any help? So if you become, the first thing to say is probably you want to go down to your local authority and ask for a Section 9 Care Act assessment, just to see if social services might owe you some help of some sort. And from a housing point of view, if the landlord does actually evict in terms of serves you a valid eviction notice, then it's highly likely with those health conditions in conjunction with your age that you would be in priority need. You wouldn't be intentionally homeless. So the council would owe you a duty. Now, I don't know if it's the same in every area, but I think councils tend to have a lot more accommodation for older people. So over 55, over 60s. And so you might also be able to apply for social housing now, where you're able to apply for it now, but there's actually might be a reasonable chance that you would get it even before the eviction notice has been served. So probably what I'd do is go on the council's website and apply for social housing. They call it 100 different things, so I can't tell you what it's going to look for. But go, Google whatever ex borough council plus housing application. That should usually get you to the page. Fill in your details, and I would say that because of the age and because of there's actually tends to be quite a few properties available, they actually might be able to you might be able to get housed much sooner than you think. I once saw someone get housed within 24 hours. They had the keys within 24 hours. They were like 67 or something. That was in Bedford, but yeah, I think generally speaking, there are more older people's properties around anywhere. Anyone want to add to that, guys?
No.
If not, the chat, there's nothing else that I can see in the chat. It has got a bit quiet. I'm a bit suspicious that something's wrong with YouTube this week because it still says on my computer that it's preparing the live stream, which it doesn't normally. But anyway, oh, hang on a minute, we've got one more. So going back to the Section 21 process, how long does it take in order to receive a court order after the end of the Section 21 given period? How long can we stay during court time? So we kind of did this exercise a couple of months ago, and we basically said even if the eviction notice is valid, you're still looking at between like 2 and 6 months in the accommodation, and that's if depending on how efficient the courts are being. So, Will, is that about sort of right?
Yeah.
So,
I mean, remember the thing here is you're dealing with a lot of variables and possibles. So you could get the landlord could serve a Section 21 notice, and then for whatever reason decide not to bother doing anything else. So the answer would be it will never happen because they've never issued the court proceedings to get the court order. Equally, the Section 21 notice could be invalid, and then they don't get an order that way. But if just assuming, just the exercise we did was, I think, was assuming that you haven't got a defence and you've got a landlord who's on the ball, you'd be looking at 2 months for the Section 21 notice. Say 2 months and 1 day, the landlord goes into court and issues it. It takes the court maybe 2 or 3 weeks to issue it. And then basically you're looking at about 4 months, 5 months before you get evicted. I mean,
yeah.
I've said that rather than go through the whole thing we went through before of all the stages.
I suggest as a way of kind of just dealing with the questions. I mean, they're good questions, they're important questions. With the really frequently asked ones, it might be worth us just kind of giving some, doing some proper videos about them. And then when someone asks a question, we just kind of signpost people to that video. But yeah, it's months of stress basically is the answer. But yeah, you can make a homeless application early on. So if the notice is valid and it's going to expire within 56 days, you can make the homeless application there and then. And a lot of housing registers will give you reasonable preference. You actually get relatively high banding in that period. So it's kind of very much worth doing at that point. Okay, guys, thanks for all the questions in the chat. We're going to call it a night. If you haven't already, do the whole like the video and all that sort of thing. Subscribe to the channel, blah blah blah. I think you guys back next week?
Yep, I'm around.
Yeah, so I think there's a trio of us next week. Keep the questions coming. Will, Shannon, and I are going to have a conversation about, as I say, whether if there's another way of doing it which is more efficient. But we'll see. Any suggestions you've got, guys, just put them in the comments on any video, and we'll pick it up. But yeah, we hope this is all helpful. And yeah, stay around for next week if you want to ask some more questions.